All right, looks like we have you. Okay, Mr. Sampson, you're up.
Thank you, Your Honor. May it please the court. Daniel Sampson on behalf of the appellants. With regard to the private offering exemption, the standard of review should be de novo. Having ruled that the stock sale was not a security, the predecessor judge made no findings of fact regarding the private offering exemption or whether or not Dr. Wish received a finder's fee or whether or not he was a dealer. The court will scour the original trial order and amended trial order in vain to find any factual findings regarding Dr. Wish. All findings of fact made by the successor judge were made on the same cold record that this court will review. Regarding whether or not Dr. Wish received a finder's fee, he spoke directly to Mrs. Grande regarding obtaining a finder's fee. There were significant discussions regarding his finder's fee, and it was determined in a letter by Mrs. Grande to Dr. Wish at record 4002 that Dr. Wish would receive a finder's fee of $90,420.20. Mrs. Grande then talks to her accountant and determines that there would be a tax implication to paying a finder's fee. And so the deal was restructured and Dr. Wish received a discount on the stock price in the exact amount, the $90,502 amount. There simply is no credible evidence on this cold record that Dr. Wish did not receive a finder's fee.
Let me ask you this. As I read the briefs, my understanding was ultimately the price in the transaction was reduced to all of the purchasers, was it not? And if that's the case, I mean, perhaps maybe to specifically avoid this question, but can it be said that he actually received a finder's fee versus just participated in a reduced price along with everyone else?
I don't believe that the other parties received the exact same reduced price. And again, he received the exact discount that was discussed as the finder's fee.
Yeah, I get that, but the question was the discounted price applicable across the board?
It may well have been. But even if it was applied across the board, it was applied across the board to avoid the tax hit. Mrs. Grande sends a letter or an email to Don Cogswell a year later saying, can you send me the documents on which Dr. Wish received a finder's fee? That is record 4145. So even if it did apply across the board, it applied across the board to avoid the tax implications of providing Dr. Wish the finder's fee. But again, that shared discount was meant to be a finder's fee, and even Mrs. Grande acknowledged it a year later in an email to Cogswell. Dr. Wish is also a dealer. A dealer is defined as any person other than an associated person registered under this chapter who engages either for all or part of his time, directly or indirectly, as broker or principal in the business of offering, buying, selling, or otherwise dealing or trading in securities. Dr. Wish was involved in 3 successive transactions: his own, Cogswell's, and Mr. Giffler.
And again, you raise an interesting question. He was involved in 3 transactions that were all part of a single deal, correct? And if that's and if it was just a one-off deal, can it be said that he, or would the circuit court have been incorrect in assuming that he was not engaged in the business of by participating in this one deal?
It wasn't intended to be just one deal. At record 9520, he intended to continue to help Spotlink obtain financing had this deal not fallen through.
Well, he may have become a dealer, but as Judge Northcutt points out, at least as to this transaction, it was one global deal, wasn't it?
It was one global deal, but there were three different parties with their own transaction documents. If I may move on to the second issue, whether or not there was a double recovery. In this case, Marta Grande was permitted to keep the 508 shares of stock that she repossessed and obtained a full money judgment. This should not have been permitted. It was a commercial, by retaking the stock and refusing to dispose of it, that is a commercially unreasonable disposition of the stock.
What is the remedy for that, Mr. Sampson?
Well, the remedy is that Mrs. Grande had the burden of establishing the value of the 508 shares. She did not, and so reversal is warranted for Mr. Githler to receive the full amount of the judgment back.
Meaning the full amount of the judge or the value of the share, or you're confusing me here. I mean, the judgment was the what was owed under the note, et cetera, plus interest and so forth, which doesn't really have anything to do with the value of the shares per se.
You would be entitled to the judgment amount back. That's our
judgment amount back, meaning that would be the presumed value of the stock, the underlying, principle of the judgment.
Right. There, as in the Supreme Court held in Wiener, when there's a commercially unreasonable disposition of the security interest, there's a presumption that the value of the collateral is equal to what was paid, the value of the note.
That's what you're looking for, because you don't really say it in your conclusion of your brief. You just said you just want it reversed, but that's what you contend the correct remedy would be for this.
The correct remedy would be for the judgment amount to be reversed and for Mr. Githler to be repaid that judgment amount. Yes.
Or repaid the amount attributable to the value of the shares. I mean, you had a judgment that was in excess of $2 million, correct? And the deal was what, 1.7 with the note? I don't recall exactly.
He would be entitled to it. Again, there's a presumption that the value of the shares is the value of the collateral.
Yeah. Right. Okay.
And so we believe that the judgment amount should be reversed and Mr. Githler should be repaid that judgment amount. And that, again, there's a presumption that it's the same value as the value of the shares. And Mrs. Grande had an opportunity to put on evidence as to the value of those shares and chose not to, despite a prayer for relief in her counterclaim stating that there should be a stock sale to remit the amount of the collateral.
I didn't put on any evidence of value either.
I'm sorry, Your Honor.
Your side did not put on any evidence of the value of the stock either.
Correct. It's our position that it was Mrs. Grande's burden.
Sure, I get it.
So,
And how was this issue presented to the trial court as far as judge, before you enter a judgment, they've got to establish this amount?
it was established on motions for rehearing.
So it was not challenged in the trial court that she was not entitled to a judgment or the full amount of the judgment, absent establishing either the amount, the value of the stock, or raising the presumption that would need to be deducted as to amount from the value of the final judgment.
I believe it was determined that the error occurred on the face of the final judgment, and that's why it did not it was not presented until motions for rehearing.
Okay, but in the presentation of the case to the trial court, the appellees moved forward on a theory that they were entitled to a monetary judgment based on this sequence of events, correct?
Correct.
And did your side ever say to the trial court, Judge, if you're going to rule in their favor, then you cannot award the full claim of damages for these reasons?
No, Your Honor.
Okay,
Not
thank
until
you.
motions for rehearing.
Thank you.
And your client paid the judgment, correct?
Correct. He was required to.
Well, I don't know that anyone ever requires anyone to pay a judgment, but he certainly did pay I mean, it was a collectible judgment, so he paid it.
Correct. It was a collectible judgment and he paid it. I suppose he could have bonded it off. But
Or he could have just suffered through collection.
I suppose that's true.
It's always a choice, but
Seems like a Hobbes's choice.
I don't know if I agree with that, counsel. We get stays and bonds in many, many cases. So, there are options.
I mean, there are all sorts of things people do. I mean, he paid the judgment. No one ordered him to pay the judgment, but he paid a judgment.
That's correct. If there's no further questions, I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Sampson. Ms. Price?
Good morning, judges. May it please the court. Kelly Garrity Price of Dentons, Cohen and Grigsby on behalf of the appellees, Marta and Phil Grande. I'd like to thank the court for your time. It's clear from the questions that were posed to Mr. Sampson that you all have read the briefs and have a good grasp of the facts, and that is going to be important here. And that's going to be important because the standard of review for this particular case, I think, is going to be critical to your determination of the issues that the appellants have brought on this now second appeal. Some of this may sound very familiar to you all because there was an en banc review and determination of the Githler 1 appeal, which resulted in the retrial that was conducted by Judge Carroll and forms the basis of the final judgment on retrial that has now been appealed a second time by Mr. Githler in these particular proceedings. The standard of review is not de novo. That has been asserted by the appellants as the singular standard of review for this particular case. And as appellees have noted, we believe it is a mixed standard of review. Certainly questions of law, interpretation and application of the law would be a de novo review. But this is an interesting set of circumstances because we have mostly factual determinations which were made by the trial court, either in trial 1 or trial 2, which are now being brought up on appeal in the context of application of the law. We also have
Can I ask you a quick question?
Certainly.
How does that affect his argument there's a double recovery going on here that he didn't know about until after the fact because the judgment was entered after the court had the hearing?
It affects it this way, Judge. Certainly the obligation to raise compliance with Chapter 679 on collateral always rested with Mr. Githler as the debtor. That is
let me ask you that, though. Let's come back. Let's assume that your client just exercised its power to, or her power to just have the stock transferred on the books to her, right?
Yes, sir.
And then just sat on the stock and never filed, and there was never a lawsuit filed on the note. What would Mr. Githler's remedy have been to force a sale of the stock?
All right, so I want to make sure I understand the question.
Okay, so let's forget that he sued your client.
Right, but
there's been a breach that caused her to get the stock back.
Okay, I wanted to make sure.
But there's no underlying litigation going on. But she sits on it. She doesn't sell it. to apply to the debt or anything, what is his remedy?
All right, so under those circumstances, I think we're dealing with something similar to what we have before us today. Just re-registering those shares in her name once Mr. Githler defaulted on the secured promissory note did not result in a disposition of the collateral. Don't forget the stock pledge agreement that existed between Marta Grande and Mr. Githler allowed several different remedies to be taken cumulatively. Those are in accord with Chapter 679. Simply re-registering those shares under 679-626 subsection 1 does not result in a disposition of the collateral. So if we're talking about an extended period of time during which that has not happened, there has been no disposition, then I think Mr. Githler's remedy is to file a suit to force a disposition under the stock pledge agreement.
So it's a suit under the agreement, or a suit for deck action, or an injunction?
I think it would probably be a suit under the stock purchase agreement and the stock pledge agreement, Judge, and also a deck action, claiming that she can't hold these forever, and that the court needs to take some action to quantify the debt. But realistically, I don't think that would ever occur or come to pass, because these shares, the 508 shares of stock that were pledged as collateral for the secured promissory note, that's what we're talking about in terms of the collateral here in what would not have been sold. In order to recover on the secured promissory note and the balance of roughly 1.8 million that was owed to Marta Grande, she would have taken some action as a judgment creditor to get that done, one way or another, to get the funds back to pay on the note that Mr. Githler defaulted on. So the creditor probably would have taken action, but in terms of Mr. Githler's remedies, I think it would be a suit on the agreements and or a deck action if she were to sit on that. But realistically, I don't think that would ever happen, because she's a secured creditor owed, 1.7, almost $1.8 million.
Can she dispose of the collateral now?
In this particular instance, Judge, now that we've gone through all of the appeals, we've gone through all of the litigation attacks on the final judgments rendered by 2 judges in this case, I think there is a situation potentially that she could, but bear in mind that Mr. Githler has satisfied the judgment.
So any proceeds of the sale would come back to Mr. Githler?
That's correct. Or as the stock pledge agreement identified, and as section 1.5 of the stock purchase agreement identified, since Mr. Githler paid the debt on the secured promissory note in full, the shares of stock revert back to him. He's got a remedy. It's just not before this court.
Okay.
So the standard, back to your question, Judge Vellante, in terms of the standard of review and the double recovery argument, I think that also has a junction point, because the first judge, Judge Moreland, the predecessor judge, is the judge that made the factual determination that Mr. Githler had failed to plead any affirmative defenses relating to these 508 shares of the stock pledged as collateral. That was a factual determination she made in trial 1. It was adopted by Judge Carroll in trial 2. So even on the double recovery argument, we have a factual determination on waiver. The case law in Florida tells us that whether or not there has been a waiver is primarily a factual determination. And that's why I think we have the clearly erroneous, mostly factual review at issue in the standard of review for this appeal. So whether you look at what the judge in the first trial found, the findings that Judge Carroll made and readopted in the second trial, and the findings he made on his own, it still does not amount to a plain de novo review for this court. That's why I think it's important in terms of the standard of review.
Mr. President, I don't recall one factual aspect about the case, and I was trying to find it right now and haven't located it. Did your client re-register the stocks prior to the lawsuit, or was it pursuant to any order of the court?
It was not pursuant to an order of the court, Judge. It occurred as a result of Mr. Githler's default of the secured promissory note. I might add, a default he admitted at trial.
Okay,
stock pledge agreement, once he defaulted, a
Now,
notice.
I understand how the stock pledge agreement works,
Okay.
but in terms of this timing sequence, did your client re-register the stocks and take it out of his name prior to the lawsuit being filed?
I believe it occurred almost at the same time, Judge, because the default notice went out to Mr. Giffler, the shares were re-registered, and then the lawsuit was filed. So
at
it's
the
in and
time,
around the same time.
at the time of the pleading still being ongoing and before trial, he was aware that the stock had been re-registered.
Oh, most certainly. No question.
That's what I wanted to make sure on the timing. Thank you.
In terms of the dealer argument, again, that is a factual determination that I think bears the clearly erroneous standard. The final judgment on retrial goes through the rationale adopted by the successor judge in making that determination. I think Judge Northcutt, you hit on this in the questions that you were asking the appellant about, was it proper to determine that Dr. Wish was a dealer in just this one instance? Make no mistake, the record is replenished with factual determinations and with evidence that this was a singular global transaction for the purchase of what amounted to a majority ownership interest in SpotLink by Mr. Giffler, Mr. Cogswell, and to a smaller degree by Dr. Wish. So this was one overall global transaction. You are absolutely correct about that. There was one stock purchase agreement. In that stock purchase agreement, you have the various parties, although Dr. Wish's 6% share that he purchased as part of this global transaction was subject to separate documents. His obligations in terms of him having to make a working capital loan and other items that related to him were in the stock purchase agreement. It has been asserted by the appellant in their pleadings that the sole evidence that existed before the trial court in the retrial that Dr. Wish wasn't paid a finder's fee was the testimony of Marta Grande at the original trial. That, however, is not true. We have a series of exhibits which were proffered by the appellees in the retrial, also proffered at the initial trial, a series of emails that were exchanged months before this particular stock purchase agreement was signed and the closing took place. And although there had been what Judge Carroll correctly called preliminary discussions about a finder's fee to Dr. Wish, those were ultimately disposed of in the manner in which Judge Northcutt mentioned in questions to appellant's counsel. Ultimately, it was determined that there would be an overall reduction in the purchase price for the majority interest in SpotLink that would apply across the board to all the purchasers. The email communications, the exhibits that were identified in Appellee's brief on that came through the pipeline and involved all of these parties, including Dr. Wish, clearly identified that not only was the reduction in purchase price going to apply to everyone, but any discussion of a finder's fee was going to be voided. So the agreement that had been proposed between Marta Grande and Dr. Wish was never signed by him. He clearly testified to that. And the stock purchase agreement itself references in a section that no finder's fee was paid and also has a merger and integration clause that says this is the entire agreement and it supersedes everything that came before, including the letter of intent, which was a document that had referenced potentially paying a finder's fee to Dr. Wish. So we've got email communications, we've got documentary evidence, we've got testimony that it was voided. Lastly, we have an exhibit in the closing statement for the transaction itself, the global transaction, no reference to any finder's fee. So clearly there was no finder's fee paid. It was more than just Marta Grande's testimony on that point. And candidly, Judge Carroll went through the analysis of what determines a dealer, looking at the Florida statutory sections on that definition, hitting the point that Judge Northcutt mentioned earlier, which is engaged in the business of. Appellants admit in their brief that there was only one instance where Dr. Wish did this, and it was this particular transaction. And on that fact, they want you to undo the factual findings by Judge Carroll, which this court is not supposed to be reviewing factual findings and making those changes, and determined that that one instance was enough for Dr. Wish to be considered a dealer. I suggest to you that that would be a rabbit hole of jurisdictional issues involving folks who do what maybe Dr. Wish had done in a singular transaction to make that law on a one-time situation under the facts that we have here, where Dr. Wish did not control the ultimate outcome of how this particular transaction was structured. We're really looking at the Edelstein case. That's really the case in Florida that identifies that a person merely acting as a conduit to bring people together in a transaction like this, where you're buying and selling stock, isn't enough to make them a dealer. That's the case. That should remain the case. That should remain the law. And I suggest that it's not proper under these facts for the court to determine that Dr. Wish was a dealer. I believe that the successor judge properly did the analysis, came to the correct conclusion. The appellees were found to have met the exemption under the under the private offering. They also have the isolated sales exemption. The evidence in this case is substantial, and the evidence in the case that is substantial supports the conclusions of Judge Carroll on retrial on all of the issues raised. There has been no double recovery. Mr. Githler did not put the issue of Chapter 679 in play in either the first trial or, for that matter, the second trial. It has not been preserved for appeal. And because it was his burden to put the issue of any disposition of collateral in play as an affirmative defense, and he hasn't, that waiver is fatal to his claim. Even if he had appropriately raised it as a defense, and there's no way you can look at his prior breach defense and say that applies to the 508 shares, you cannot get to the ultimate relief that Mr. Sampson has told you that they want. The ultimate relief being that they want the 508 shares to be valued at the same purchase price as when Mr. Githler purchased the stock. That is not supported by the case law. The Wiener case is a case that talked about an improper disposition or sale of collateral. The facts are clear in this case that under Chapter 679, as it exists today, and as it existed for this transaction, there's been no disposition of the collateral. Virtually all of the cases relied upon by the appellants in this case on the double recovery argument predate the modification and revamping of Chapter 679, which occurred in the 2000s. It is all older case law that doesn't follow the current statutes and the obligations that fall to a secured creditor and a debtor. The Wiener case is not applicable. We don't have a disposition of collateral. The other cases that they cite all predate the revamping of the code. And the stock purchase agreement and the stock pledge agreement clearly do not support the argument that these 508 shares can be valued at the original purchase price. There's one section in the stock purchase agreement that talks about that. And it's section 1.6, which addresses the 303 shares that Mr. Githler received when he closed on this particular stock purchase transaction. Those are the shares that came to him when he paid essentially a little over $1 million at the closing. The remainder of the purchase price was tied up in the security of the secured promissory note. He received those 303 shares. The stock purchase agreement says if he defaults on the secured promissory note, or if there's other defaults and he still owns those shares, then SpotLink has the obligation to buy those back at the purchase price of the original shares. That's clear that it applies to those shares, but those shares aren't collateral. Those shares belong to Mr. Githler. He owns them today. The stock purchase agreement refers to the stock pledge agreement in determining how those 508 shares will be valued. And the stock pledge agreement has provisions in there about how you do it. And nowhere does it say it equates to the value of the shares at the time of the original sale. To allow that remedy would be to not only disregard the current confines of Chapter 679 as they existed when this case went to trial and when Mr. Githler defaulted, but it also gives him a windfall because those shares are not worth Those 508 shares are not worth what they were when this deal was done because of the financial ruin, near financial ruin that Mr. Githler and his comrades in the purchasing group caused this company after they took control. And that was well documented in the initial trial and was in the record that Judge Carroll reviewed upon the stipulation of the parties to utilize the original evidence on the retrial. So that would be a windfall not supported by the agreement, not supported by the law, and certainly would reward Mr. Githler for his bad behavior. Again, a remedy and a result I don't think this court would want to award, and there's no need to award it in our opinion.
Thank you, Ms. Price. Mr. Sampson, I have you at about 6 minutes to go. And you're muted, Mr. Sampson.
Thank you, Your Honor. I'd like to address first whether or not it was factual determinations made on the double recovery issue. They were not. They were legal determinations. Whether or not the second affirmative of defense regarding the 303 shares of stock applies to the 508 shares. Whether or not the counterclaims prayer for relief put into issue the value of the 508 shares. Those were legal rulings, not factual rulings. We agree that ordinarily, and this is the Spellman case, ordinarily merely repossessing the collateral is not a disposition of that collateral. But the Spellman case also notes in footnote 5 that once repossessed, the secured creditor cannot merely put the collateral on the shelf. They must dispose of it in order to protect the debtor. They argue that the litigation prevented the sale. There's no reason for this. If Mr. Githler were to prevail and there would be a rescission of the stock sale agreement, the shares would revert to Mrs. Grande. She was able to sell the shares over the last 6 years. She could sell them now. Instead, she put them on the shelf and we got a full money judgment against Mr. Githler. We would contend that that is the unfair result here, that is the windfall result, that she was able to retain the shares and obtain a full money judgment. And again, the Spellman case relied on by the appellees explicitly states that this, the appellee could not do. They argue that it's older case law, the Coates decision, the Wiener decision. Those cases rely on statutes that under the new code have the exact same language. The statutes have merely been renumbered. Those cases apply with equal force today. We would request the court to reverse either on the private offering exemption or on the double recovery, and on the double recovery to remand with instructions to provide Mr. Githler with the full judgment amount. Thank you.
Sampson, thank both of you. In order to leave our virtual courtroom, you should click the button that is surprise called Leave on your Zoom screen, and you'll be gone.
Thank you, judges.
Hey, thank you both. Take care. Have a good day.
Thank you, Your Honors.